third or fourth, perhaps, after English. But thank you very much for that presentation. I'm going to throw this open. We have 45 minutes to go, and we will welcome both questions from the floor as well as perspectives from individuals and jurisdictions, both which aren't represented on the stage and otherwise. And I had messaged a few minutes ago Mr. Amarjit Vedi as to whether we have a bunch of microphones which are sort of moving around. But if not, that's part of the responsibilities of the chair. So let me just know, I'll just head down there. Come, please. Nixon, you're next.
Hi, this is Jose Marley from the Hong Kong Bar Association. So just in light of what President Warner and also Ms. Lisa Sam said about the downside, in a way, of court hearings either being basically shown live to more people or for the advancement of technology, is that has really caused an upsurge in doxing, especially as societies become more divisive. And we can see this whether it's the UK, the US, Hong Kong, or elsewhere. And it's basically created a greater ease in which people who don't like particular rulings then end up attacking judges. And as the last speaker mentioned, this puts pressure on judicial officers. And so one of the experiences we've had in Hong Kong, as you all know, is we faced some pretty difficult times in 2019, as a result of which some judges were doxed. So depending on whether you came to a ruling which Camp A liked or Camp B liked, you got basically doxed by one, sometimes if you're unlucky, both camps, depending on the result. And so on the 13th of November of 2020, actually, Mr. Justice Coleman was faced with an injunction. So the applicant was the Secretary for Justice, which in other common law jurisdiction is the Attorney General, basically applying on behalf of the judiciary to prevent doxing. So of course the hearing has to go before a judge. And just to give you the sort of facts you can all recognize in your own jurisdiction, paragraph 19 of the judgment says this. It says, in that section on behavior, that's as in the affidavit which was filed by a judicial officer, but whose identity was anonymized because you didn't want him to be doxed. Typical posts included, quote, pro-China, pro-communist. Others were, quote, support Hong Kong police. Some of the posts suggested that the judge should, quote, die of bad fortune, that the doxing comment should be continued until he or she is, quote, sanctioned, or, quote, someone hits. One post suggested the whole family of the judge should die. Another proposed the use of a firearm. And I could go on, and I'm not going to read it. People's phone numbers were leaked, the families, the children, and so forth. But one important paragraph deals with freedom of expression, because at the same time, I think we all recognize that there's a balance between being able to criticize court judgments, which we all accept, and moving on to the unacceptable, which is to basically threaten judges and judicial officers. So the judge there says, Mr. Justice Coleman says, I accept the injunction sought may have the effect of restricting certain fundamental rights, including the right to freedom of speech or freedom of expression, as guaranteed by Article 27 of the Constitution. However, the court is to perform a balancing and weighing of various relevant rights and freedoms, including the rights of doxed persons and their family members to respect privacy, as well as the need to maintain public order and confidence in the administration of justice. In any event, it is only unlawful doxing which are intended or likely to intimidate, molest, harass, threaten, or pester, which are sought to be restrained. So this is not always a very easy balance between saying, well, I'm just attacking your ruling, and by the way, I put your photo and I mention where you went to school, to what is actually intimidation, which was mentioned by the last speaker. So I think this is something which the legal professions as a whole, I think, need to think about, because we all know the judiciary in most places can't speak for itself. Thank you.
Thank you, Jose. Nixon?
Thank you very much. I'm Nixon from Peradi, Indonesia. I'm interested to know first about the presentation from Lisa, the relating between human rights and the social media. Is there any national law from Singapore regulates the infringement of AI and social media into the human rights of the citizen of Singapore? Is there any national law of Singapore regulates the infringement of AI and social media into the citizen of Singapore? And if not, how do the lawyers in Singapore defend or claim the rights of human rights in base of human rights to the infringement which is not regulated yet in the national law of Singapore? And that's for Lisa. And for Juliana Warner, in Australia, interesting to know about the case of 70% the ethical, yeah, the survival of sexual assault, yeah. And how does the court determine the right or correct evidence? Because lots of data at the moment in the media and the proceeding, and then then how does the court determine, and how does the barrister or lawyer in Australia present it for evidence, digital evidence or social media evidence for defense the plaintiff or the clients? Is there any guidelines for doing proceeding evidence to determine which data is the correct one from the plaintiff or from the social media or from the AI? And the third, because it's interesting, as Mr. Syam Divan came to Indonesia last week, and I also interesting to about the AI and the investment of AI, especially into the personal data protection. We all now is monitored by AI our data. So at any times, we all may lose or stolen our data by AI. And I don't know whether we all here understand and worried that our data, is including the data of banking, will be, announced to anywhere in the world, so everybody can know our account banking, how much money we have, how much money, how many houses we have, and everything can be opened by AI and social media. And this is what my concern now is. Is there any convention, international convention to regulate about AI, social media, so we can have like narcotics, we can have a transfer any suspicious criminal in AI. Because now as far as I know, there is no convention, law of convention in terms of AI and social media. And I'm really worried if we don't have a special convention in the AI and social media, we are now playing victim by, play around by the any company, anyone who understands very well about AI, and they can sell our data and get benefit illegally from us. Thank you.
Thank you very much, Nixon. Before I let's get answers from the floor to Nixon's questions and his perspectives. He's, of course, as you gathered from the last part of his comments, a data protection expert, private data protection expert practicing out of Jakarta. So Lisa, would you like to go in first? Just your response, and then we can go across to Juliana.
Okay, I will just talk about Singapore court proceedings. In Singapore, we had some political cases, and it went into the social media domain, and the court then switched tracks and basically disallowed any recording by anyone in court. The recording is, however, kept by the courts, and no one is allowed to make any video or audio recording. Okay, so that's the first step they did. They also enacted the Family Justice Act, Section 10, to anonymize all family-related proceedings, not just the details, but also the name. So these days, when we want to cite a case, it goes AAB versus AAC or CCBB, and it's quite difficult. So that they also anonymize a lot of the companies and addresses which can identify a particular person. And so in recent times, there is, right now we are looking at transcription, because people bring computers in and they just turn on the app, and you can have a transcription of what's going on, where you could in the past take notes. So we are now actually in the midst of a discussion about using apps to transcribe proceedings. Of course, there is an official one from the courts, but that is under discussion, because people can easily use the transcription and take it to the public domain, and the accuracy is another thing that you have to deal with. So that's what the court had done right now. So a more conservative approach. Then, of course, with the usual publishing of judgments and all that. So what does the Law Society do for our lawyers? We conduct quite a bit of training together with a social media PR experts, basically to teach our lawyers to identify when to respond. Because sometimes some comments can be like a troll, and if you respond to it, it can make it worse. So it is not uncommon for people who receive letters of demand, they receive the court proceedings, to publish the court documents online, and then people will pass comments about, oh, you know, you're bullying somebody. So I give an example where someone went to eat somewhere, and he published a comment about this restaurant, oh, it tastes awful. And the restaurant took proceedings in court to injunct the person from commenting, and the lawyers got involved, and it just went downhill thereafter. So I think training lawyers or law firms to know when to respond and how to respond is important, because it can be perceived as trying to stifle freedom of expression. And if the lawyer is dragged into that conversation, it would not look very well for the profession as well as for the law firm. Then everyone says, oh, you should boycott this lawyer. There were even trolls, like there were typographical errors in the letters of demand. And the comment was, oh, you know, you can't even spell properly, and therefore you're not a good lawyer. So that's a troll. So I think helping lawyers to identify when to respond online is very important. Sometimes the best way is not to respond. Okay, so that's one of the things that the Law Society has done. I mean, apart from the usual criminal offenses that are out there, there is no specific hard law. There is a rule, I think, which is present in most common law jurisdictions, is that when you get evidence from a current proceedings, you can't use it for collateral purposes. So the courts do enforce that with contempt of court, even if the parties are the ones who abuse it. So these are the soft approaches. But in general, I think because it's difficult to control once your information is in the public domain, the court has taken a very conservative approach. But no hard law has been put in place to limit people's ability to comment. Okay? Just let me see what your other questions. Have I answered all your questions? Yeah, okay, good. Hello, can you hear me?
So first of all, in relation to, I think you asked about recording in courts, similar questions to Lisa. You can't record court proceedings. You can just take notes, like in the old days. If it's live streamed, the federal court has its own YouTube channel, which is different, but you can't transmit that or record that and send it off. But again, you can take notes of whatever is said. In relation to protection of judges and families and so forth, any cases involving children, you can't use the children's names. They're all anonymised. In fact, there was a court case a few years ago where a sexual assault survivor had wanted to.
Sorry, Julia, can Julia be heard at the back? Yes, okay. Sorry.
Okay. There was a case where a sexual assault survivor had wanted to use her own name in the press because she wanted to disclose what had happened to her. She'd been groomed by a school teacher as a young girl, and it had been immensely damaging. And she brought some proceedings in the Tasmanian Supreme Court to get a dispensation so that her name could be used. She ultimately became Australian of the Year. Her name was Grace Tame, and she became very famous for defending sexual assault survivors. But the general rule is that no names are for minors are used in proceedings. In relation to how jurors are protected, again, no photography, no names of jurors are ever made available. They're all told that they mustn't look at social media or read the newspapers while they're in hearing, and the judges reinforce that at all stages. But I think that's really the limit of what has occurred to date. Yeah, I think that's really where we're at in Australia at the moment.
Thank you. I wonder whether Roden or would Jung Woo have any comments or any supplementary remarks? What about Chen? Would you like to comment on any of the remarks which have been made or reflections, or should we just move the questions along? Okay, okay. Anyone else? All right, fair enough. Yes, please. Yeah, please. Thank you.
Very short question. What do you think about the use of platforms of AI by the judge or other participants in the court system? Will it affect the equality of parties before the courts? Because as there will be a huge difference of resourcefulness and support between those who have access to a privileged and well-resourced AI system and those who has not. And in the sense of this, if any judge is allowed to use AI, shall it be freely accessible to all parties and also to the public, and be a part of public service infrastructure to maintain equality in uniform manner? Because as, for example, as Ms. Lisa indicated, there are certain transcribers and other types of programs, and if court is using it, shall it be accessible to everyone? And if court is using some kind of AI, shall it be accessible to everyone as a public service in order to maintain equality between all the parties? So as I understood, in reality, there are paid and specific AI platforms who is not available to everyone, so that attorney who has access to it and attorney who doesn't have access to it will be having a huge difference. And will it be in line with the principles of equality between all parties, considering the advantage of the technological advancements, right?
So, thank you very much for that question. So it's really about a level playing field. And
Yes.
I think there are at least two dimensions which come out here. One is a level playing field as between two sets of lawyers. and the other is the level playing field between the court on the one hand and the sort of the members of the bar. So I wonder whether there are any reflections on this or any responses to this. Yes, please, Juliana. Yes. And perhaps you could even touch on the issue which was raised, which is, the larger issue of access to justice and costs.
Oh, yes. I was at a function a few weeks ago, which was the 30th anniversary of what we call OSTLI. And OSTLI is a database of all legislation and case law in Australia, in all Australian courts, and all legislation, and it's free, and everybody has access to it. They are developing a large language model based only on the OSTLI database, which they propose to make available to everyone. And I think what they are aiming for, in conjunction with the judges, is to create that level playing field for judges and all participants in the justice system. It's quite a novel approach, and it's completely free.
Thank you. Thank you. Yes, Rodden?
Well, I think, Sharma, I agree with you. It's just a matter of level playing field. Look at that. As I mentioned in my speech, frankly, at the end of the day, it's not about yes or no. It's about when. So at the end of the day, I think it doesn't viable if we do not allow any of the legal profession to adopt AI. Think about it, just using Lexis, for example. They always come to us and doing a presentation that day, okay, our AI model is within our own system. So literally, it ensures that the genuine of all the cases. There's no fake cases, anything. That's something that they always advocate for. I think the UK is already, they implement it. For Hong Kong, I believe that is about next year. That's what they mentioned to us. Yeah. Yeah, of course it's by charge. There's no free lunch. Yeah. But then, I think responding to this question is, okay, we still can, using human discretion nowadays, to control for the judiciary, for the legal profession, how to adopt AI. But my question is already saying that how many years we can still do it, we do not know. That's something that I think none of us can say. Because, think about AI, we're only talking about in these 2 years, it's dramatically changed. For example, in Hong Kong now, Court of Final Appeal already start to adopt some sort of trial online, so people can actually view it. Mainland China, they have trials on the internet that you can view it lively. So we are gradually changing. I'm not quite sure about in India, but what I'm trying to say is, at the end of the day, we will have to face it. Yeah.
Yes, thank you. Any comment on here?
I agree.
Yeah.
I agree that it's a question of when, not if, because when we look at what's happening in South Korea, for instance, I believe that South Korea the Bar Association, of course, has gone through long legal battles with AI platforms trying to regulate it. I think it's a question of how we regulate it, because I think that a lot of people are using it, and the public especially is already using ChatGPT before consulting an attorney. So I think it's a question of how do we regulate it and how do we fairly make a level playing field. Thank you.
Can I make a comment, Sean?
Yes, please.
Yeah, I mean, I like the discussion and I think it's correct, but if we are really honest, I think we mix up a little bit. AI, for us, artificial intelligence, we believe will be probably the one who is for us deciding. At this stage, AI, ChatGPT, DeepSeek, whatever, is basically a language-based search engine. If you look at ChatGPT, it helps you to quickly scan the internet, and it comes and then gives you an answer which is much more easy to read. The access to legal information was always a bit inequality. A big law firm always had much more research capacities than a small law firm. So from that perspective, I think we have to watch a little bit that we are not confusing the real challenge with what we have now. Now we have tools which make life a bit more easy. Also before, when I did my doctorate, I went to the library. I didn't probably catch all opinions, and maybe I got some opinions out of context, so therefore they were a bit biased. The main issue, I think, is do we move into an age where the computer is making the decisions? The algorithm is fed with facts, and then this algorithm makes the decision, therefore replacing be it the lawyers or the judges. And in that case, we have this bias and the question mark, how do we regulate AI not to overcome this human judgment? Last comment, we basically praise the human mind and the judges, and basically they're biased as something more acceptable, more trustful. There are researchers where also some people say, well, this is more for a discussion, maybe the next time on the 36th POLA Summit, maybe the judgments we have partially now are much more biased than if a computer would do it. So I think that's where really the battle will lay in the future, to have different research tools shouldn't scare us.
Thank you very much. Yeah, I'll just turn the microphone over. And before that, if I may just make 2 or 3 quick comments. The first is that I suddenly confronted this issue of level playing field when I was writing a message for the moot court, the Law Asia moot court, which is going to be held on the side of the Law Asia annual conference in Hanoi this October. And it struck me as to whether Law Asia has any moot court rules regarding the use of AI. Because I was it was fairly obvious that there were going to be certain teams who are going to prepare their memorials and research on the strength of AI tools, and there were going to be likely others who didn't have that advantage. So it's, it strikes at the very heart, but at a very basic level, even when you're in law school, as to this disparity. And I think what we looked around, and there are certain international moots which have introduced certain norms for mooting and use of AI, and we probably will have to put some rules in place for the 2026 moot competition, though we don't have it here. A couple of perspectives on where AI can play a big role, because I picked this up from our expert panel. One was initiatives by the government. The other is initiatives potentially by the Bar Association, and just to ensure that people have access to AI. So it's just introduce 2 or 3 thoughts here. One is, in a country like India, AI has a tremendous role in terms of access to justice because of the languages we speak. We have over 22 official languages. If you see one of the Indian currency notes, if you've happened upon them, you will find the notations in different scripts. And there's many, many more languages. There's over 500 languages which are spoken here. So AI, in terms of just translation, is an enormously helpful tool in terms of accuracy and enhancing, the statements made by witnesses and ensuring that that comes in an accurate form before a judge who may or may not speak the language. So that's very, very big. The second area where, and I pick up on the thought that it's being used which Juliana mentioned, in the family court jurisdiction. When you look at the graph or the pie chart of pending Indian cases which are holding up courts from doing other business, we have 2 sets of cases which are huge. One is motor accident tribunal claims, and that the feeling is something which can be, you know, that entire tower can be demolished using AI, because it's pretty standard form. And the other is a whole huge number of cases which are actually on the criminal law docket, and they're because checks bounced. So I realize that in many parts of the world now, checks are, you know, is an ancient technology. But in India, it's still in use. We've of course got a huge digital payment network now in India, which is catching. But this is another pendency area where it's a very simple case, and we may just have to have an AI judge or a tool which can really progress those types of matters. But those were just a few comments from the home jurisdiction here in India. May I just pass it on for some more questions?
A very good afternoon to everybody. I'm Dr. Pooja Agarwal, and I'm representing the Bar Association of India. I would just like to give certain comments with regard to live streaming. We have been discussing about AI, but when we talk about live streaming in India, from my personal experience, I have some bad experiences. For example, during live streaming, the entire proceedings are being live streamed. But there are certain YouTube channels, they just take an excerpt from a particular proceeding and they publish it by putting a headline, or we can say a punchline on it, and it comes out as a very viral video. The second thing is, we are professionals. We know what to do, when to do. There are certain times when we don't speak in the court due to a certain reason, that maybe we don't want to open our trump card or whatever it is. But with live streaming going on, the clients now think that, oh, my lawyer is not performing well in the court. They are not speaking. But they don't know the reason why we are not speaking at a particular point of time. They are not professionals in this field, and that is why they engage us. So these are certain disadvantages which I feel that it needs to be looked into. Thank you.
Thank you very much, Pooja, for those perspectives. Is there anyone else in the audience who would like to raise an issue or share a question? Anything? Anyone? Well, I would just like to do a quick straw poll and request everyone in this room, most of us are practitioners, how many of us on a daily basis use AI in the course of our work? Okay, so should we start? All right. Well, there's the experts on the panel. Yeah, if you could just sort of raise your hands. All right, fair enough. A few, but it's not sort of completely pervasive across the Asia Pacific, as I can tell, at least from here. And the second question is, how many use social media for the purposes of, projecting cases either through their bar associations or through their client base? Is there anyone over here at all? Okay, is it essentially through the bar association, or is it also the firm?
Yeah, Law Council has
Law Council, of course, has
media
has a wide reach. Okay. Thank you very much for those. So I will just, well, I don't need to be up there because I have a microphone. I just have a few other questions essentially directed at the panelists, and I'm going to request them to respond as they please. But may I just inquire from Juliana? There is this, we're talking about social media, and it was essentially in the context of courts, how it can, influence public opinion and the problems that faces. But Australia has a remarkable initiative in terms of legislation as far as access to social media and children are concerned. So if you could just tell the audience about those developments, and if I may immediately thereafter come across to the Korean example, because we just learned that Korea has banned cell phones across all schools. So how is, what prompted that, and what do you think the fallout will be on Gen Z and the youngsters who go to court? Yeah, please.
There's a lot of concern in Australia about the effect that social media is having on our youngsters, particularly the 10 to 15 year age group. There's a lot of concern about mental health issues developing in ways that we've never seen before. There's online bullying, there's inappropriate sexual stuff on social media. And our new Attorney General, funnily enough, has young teenage children. And she was previously the Communications Minister, and she's an expert in telecommunications and digital law. And she has brought in legislation that bans social media for children under 16. Now, everybody knows that kids will get around that, but it's seen as better than nothing. Having said that, the Law Council sort of wryly makes the point that it's good for this government our current government, to be recognising the damage done to children by public shaming and social media under 16, but we still are incarcerating children under 14, and that's unacceptable. So we make that point regularly, but we do applaud the social media legislation.
Is it without precedent globally? Is it a first?
I think it's a first.
It's
yes.
a first. Okay.
Yes, the social media tech bros in the US are not happy about it. The government has also sort of taken on the tech giants, because they're trying to make the tech giants pay for news content that they lift to put on their platforms. So there's a bit of tension there.
Okay.
Yeah. So for South Korea, I think it's a very interesting point of contest, because South Korea has recently banned cell phones in schools. And a lot of that is, I think, similar to what we discussed today, because a lot of the rationale behind that movement was because parents were live streaming, secretly live streaming how teachers were educating students, and they would lodge complaints and litigate against teachers, especially in discrimination cases, and that led to that was a huge impediment to bar any mobile phones from being accepted into schools. That being said, recently, still, even after that ban, parents are still live streaming teachers' education methods, and we're currently disputing in court whether that would be fall into illegally contacted evidence. So that's something. Yes. But yeah, that's something that's currently underway and is currently in the appeals court. So we are looking at that very closely to look at the results.
Thank you very much. Of course, the Korean Bar Association, I have to say, played an absolutely stellar role when it came to what was mentioned a short while ago in terms of the martial law being directed and Parliament being convened. And within hours, I was speaking to distinguished representatives from the Korean Bar who serve on the executive committee of Law Asia. And initially, there was complete disbelief. So, the way it worked was that many people thought it was fake news, because it was just felt that it was just impossible that something such as this would happen. But then when there was a realization that, that there is truth behind this move, there was a very swift mobilization. Social media was absolutely the key, because that was the manner in which the message got across. And the KBA was swift in making statements and providing guidance to the members of the public, which I'm sure at a certain level, was a form of public education which was absolutely essential at that point. So that's very, very significant. I was wondering whether, Chen, you would have some additional perspectives on innovations which are being used in China. In terms of, as you did mention that, look, we don't want algorithmic justice, the rule of law, ethics, these are some of the challenges. But are there any sections, because China is so far ahead of the rest of the world in this particular area, do you have any successful dispute resolution models which are entirely AI generated? I know that in certain types of consumer disputes, low-level cases, parties can actually agree to AI-enabled arbitration. Is that catching on, or does that happen, or is it still very experimental?
Okay. So first, I'd like to share some just legal framework on the China. There are data protection law and internet security law, and also personal private protection law in China. Just as your question you mentioned, I think there are also some cases to illustrate such kind of work. But actually AI is widely used in China, also in courts. As far as I know, there are a widening application in international arbitration, but we are still believe the AIs cannot replace judges or arbitrators. But frankly speaking, it can first greatly facilitate their adjudication, and also especially international arbitration. And just take QnA arbitration committee in my city, for example. We use a lot of AI or DeepSeek in the arbitration. Also some in the people's courts. I think.
Thank you very much. Thank you.
Thank you.
Any further comments or questions from the floor? I'm happy to, if in the meanwhile there's been anyone who has some further ideas or sharings, and this is a good time to, yes, please.
Hi, my name is Jaya from Malaysian Bar Council. I think it's understandable that there's a lot of concern in the legal profession insofar as the impact of AI is concerned and how it will affect the way the judiciary operates as well. But I think we should not overlook the fact that AI has actually helped to level the playing field within the legal profession itself. Because firms that are big, the established firms, they have all the resources financially to deal with. Whereas smaller firms, at most of the time, they were not able to compete because of the limited financial resources, logistics, and location. But AI has helped to increase the game for the small firms, especially those operating remotely with limited financial resources. So therefore, I think the bar, apart from educating the public and the profession about the potential risk of AI, should also look into exploiting AI in order to level the playing field within the profession itself. Because that ultimately helps access to justice, it improves access to justice. Why? Because it adds weight to the principle of equality at arms. When both parties goes to court, there should be some level of equal playing field, equal at arms, in order for the access of justice to be meaningful. So therefore, I think the bars, while educating the public, forewarning our members about the risk of AI, should also look to use AI to increase the abilities of our firm, especially those mid-range and smaller firms, and those operating from remote locations. Just a comment. Thank you.
Thank you very much. Thank you. Any other comments or observations? Any other questions from the floor?
Yeah.
Okay, so I'll just, a couple of sharings. One is with regard to virtual courts, which came about, courtrooms without walls. And in India, again, what happened was that there was an enormous explosion of networks during the pandemic. Soon after the pandemic went into retreat, you had a situation where several of the courts, which were fully rigged up with the apparatus, were sort of started dismantling and mothballing all of this equipment and saying we're going back to the same old school method, which required an administrative intervention by the Chief Justice of India, and Justice D.Y. Chandrachud sort of sent word across to all the tribunals and the courts across this vast country saying that no, we've set this up at great expense and cost, and it must be available to citizens who want to access this. Now, who want to use the virtual courtrooms. So there's still a considerable amount of resistance among certain judges who are much more comfortable in the old sort of physical courtroom space. But there is, across India now, an option which is available. This is enormously efficient for a number of, well, essentially for the litigant, because the litigant in a tiered and a vast system like India, where you probably have to engage lawyers in different cities, if you want, the court I practice is the Supreme Court of India. But each of these cases is started at a lower level, district level. And it could often happen that the district lawyer is just more familiar with the case and more passionate about it, and is probably in the client's interest more likely to be able to persuade a bench. Now, this wasn't available earlier, but with virtual courts, the client has an option of sticking with his lawyer and not necessarily going to a lawyer in another city where the appeal is being heard. So I think that's certainly an improvement. A second element here in India was, it has to do with the bar, essentially. And it had a huge gender advantage. So what we found was that because of, you know, our society being structured as it is, which is in terms of gender biases and social responsibilities, which you know, go with a largely patriarchal system, young women lawyers found the virtual system a tremendous advantage. And they found it an advantage at many levels. First, they could do it from the comfort of an office space or a residence and access the court and present their cases, which otherwise they would have had to probably abandon a set of their responsibilities. And so they felt invested in this system, and they felt that this was a very favorable manner of doing work. They could strike a much better work-life balance that way. Secondly, and I'm not sure how many of you have visited an Indian court, but even our appellate courts are very, very crowded. So women just found that much more comfortable working out of an office desk and making a presentation than all the jostling which is associated with a typical Indian courtroom, and, you know, the physical brushing. So there are these new technologies certainly bring about huge advantages. Just one final point in terms of access to justice and the level playing field issue. The point arose for the first time, I reckon, sometime in the 1990s, long before AI. But we had this huge inequality when the first computerized databases for research came along. And the large firms, as we mentioned, and the well-heeled lawyers were able to afford these databases. And suddenly you didn't have to go into the physical library and pull out books, which became a big, big advantage for those who could pay these subscriptions. The way that model worked out was that several bar associations and bar libraries negotiated with the computerized databases and allowed a subscription model by which lawyers didn't have to pick up the entire package, but could subscribe through the library for an hour or two. So that's perhaps, in terms of these powerful AI tools which are coming about, both courts can make it mandatory, or courts can develop their own AI tools, or bar associations can enter into some sets of negotiations with the AI providers to ensure at least the large language models which are generic in nature, not the ones which are tailored to a particular firm, those become available at a reasonable cost. So I thank you all for for attending this session. It's been a real pleasure, and may I request each one of you to sort of acknowledge this brilliant panel in the traditional manner. Thank you. Come, make the announcement. Yeah. Sorry.